this is what Maxine Waters was screaming: defy the court, right? To hell with the Supreme Court. We will defy you. They're defying federal law.
Welcome to Christy Lee TV, or KLIM.news. I am Christy Lee, and obviously a major court decision, a Supreme Court decision has come down. Polarizing feelings abound, and we're already seeing a lot of the violence happening, but also the reactions, and also a lot of questions. So we're hoping to sort that out with Susan Swift, my guest today. Thank you for joining me.
Thanks for having me on.
You bet. Susan is the Vice President of Legal Affairs for the Right to Life League, and also a former litigation attorney in Los Angeles, of all places. And so, Susan, I do have a lot of questions about what this really means, because, you know, I came from mainstream media, and I've learned that you can't trust what the mainstream media is putting out there, or the politicians that the mainstream media is serving. So we're already seeing a lot of comments, AOC putting out there the term outlawing abortion, which really isn't what this is. So in short, what does this mean?
It's a landmark ruling. Dobbs is a landmark ruling. What it has done is it has restored a balance to our Constitution. The concept is called federalism. Our Constitution, by its very creation, limits the power of the federal government, because the founders didn't want centralized power, kind of like Marxism. They didn't want that. They wanted to make sure that the people in the states had more power than the federal government. And so the Constitution limits the power of the federal government and the courts to enact laws or to interpret laws. And so in Dobbs, what has happened is the Supreme Court has recognized that the prior case, Roe versus Wade and Casey, were decided erroneously. They created this right to abortion out of whole cloth, out of the penumbra. It was an activist court, and it was a very badly written decision. And so what Dobbs did is recognize, well, that usurped power from the states, because there is no right to abortion in our Constitution. And because there is no right to abortion in our Constitution, that issue has been reserved to the states under our constitutional system. So they've just restored our Constitution, and they've fixed the problem that Roe created 49 years ago. And now the issue goes back to the states. It doesn't outlaw abortion, by the way. Nothing happened other than we corrected a problem with the interpretation of our Constitution from Roe versus Wade and Casey. And I've heard people say, well, stare decisis. You have to follow the rules of the court, the Roe versus Wade and Casey. Well, you know what? If stare decisis meant what some of these ignorant people think it means, it would mean that we still have Plessy versus Ferguson, and we have Dred Scott, and people are slaves, because those were decisions that the Supreme Court handed down long ago. And if stare decisis bound us to those, well, we couldn't have overruled them with, Brown versus Board of Education or anything else, or Civil Rights Act, right? So stare decisis, all that means is that you must respect the decisions that go before, you must examine them. And if they are found to be incorrect, you are bound by your duty as a justice to correct the error. And that is what the Dobbs court has done.
And you're using stare decisis, is that what you're saying, that term?
Yes, that's the concept that says that courts should follow the rulings that have come before it, so that you don't.
Yeah, so I understand that more. I mean, as somebody that's not in law, this argument of precedent. So like, you hear a lot of people being like, how can they do this? This was a precedent. How can you overrule a precedent? So my question is, does the fact that it was never codified into law, is that what made it possible, or does that have nothing to do with it?
What precedent says is that you follow the cases and things that have come before in general. It is a guideline. But again, let's examine the Dred Scott opinion, right? That concerns slavery, and Plessy versus Ferguson, right? If precedent is binding, so binding that we cannot deviate, well, then we should still have slavery in this country. You see, that's why these analysts that are saying that, oh well, Roe versus Wade was precedent and stare decisis demands that we respect that law, right? Well, not if the law was incorrect. And what stare decisis means is you must respect the law, you must examine it and see what the ruling said. And they've done that in Dobbs. It's a painfully long decision. And what they do is they actually go through the common law and history of the United States. They examine all of the different legal rulings as well as common law history, and they correctly found that our Constitution, nor our history, we don't have a right to abortion. And so they had to go and overrule Roe versus Wade and Casey because those two cases were erroneously decided, and now Dobbs has corrected that. So that's what precedent is you look back, you respect what has gone before, you examine it, and if it is valid and true and good, then stare decisis says, yes, we will continue to uphold that. But if you examine it and you say, well, this is wrong, as in Dred Scott, as in Plessy versus Ferguson, right? And you say, well, no, people cannot be owned, they can't be slaves. You can't have 3/5 of a person, right? We look at these laws and you say, no, that's wrong. We must overrule those cases. So this is exactly the same thing that's gone on in Dobbs. Roe versus Wade created a right to abortion that never existed in the Constitution in the first place.
Why is there so much talk about, well, why didn't they codify it into law when they had the chance? Why is there this talk?
Well, what we're going to see on both sides, now that the issue of abortion is correctly back in the states, we already have seen a divide. I think 26 or 27 states have already put in place trigger laws that protect the unborn and also women from abortion. And so we're going to start seeing that play out across our country. And one thing that I think, I know that the pro-aborts are already starting, and I believe that we should all start ourselves as pro-life. We need a constitutional amendment that proclaims the right to a person, right? The personhood amendment, that from the moment of conception, you have a right to life. So we need a right to life amendment to the Constitution. What would that do? That's different from passing laws in Congress, right? Or an executive order. Please, Mr. Biden. Anyway, it's different if you pass a law, a statute. What can happen is after the law is passed, people can challenge the federal law as unconstitutional. It can go up to the Supreme Court, and the Supreme Court can then look at the statute, like perhaps this new gun legislation that's just gone through. I haven't looked at it, but let's say someone challenges it. It could go before the Supreme Court, and the Supreme Court could say, yeah, that statute's just not constitutional for whatever reason, and striking that statute. That happens all the time. So what do you do if you disagree with a Supreme Court decision? Well, you have to amend the Constitution. And that is the only way that we're going to fully protect the rights of the unborn. And the other side recognizes that's the only way that they're going to ever be able to enshrine a right to kill babies. So they're going to try to propose a right to kill babies amendment into the Constitution. That's what they're going to try to do. And what we should be doing is we should propose a personhood amendment to the Constitution. And once that is part of our founding document, then the Supreme Court can't overrule the constitutional amendment. That's the balance of power that our republic recognizes. We have three branches, right? The executive and the legislative and the judicial. So the legislature can do certain things, the judicial can override it. But if we all amend the Constitution, and it takes quite an effort to do that, then that changes the founding documents which courts look to interpret new law.
Right. But that's what you're hearing about on the other side, is this push to pass a federal law to protect women's rights to choose, or protect the right to kill babies, however you want to look at it. So if they do try and move forward with a federal law, like you said, that can only do so much, because that could then be challenged and taken back to the Supreme Court on this ruling.
Yeah, we have binding Supreme Court precedent, Dobbs, which says there is no right to abortion. And so a federal law that would come up and saying, well, yeah, there is a right to abortion, it's going to run right up against the Dobbs ruling, and it's going to be struck down as unconstitutional. It's very clear now. The Dobbs case has said, no, we don't, there isn't a right to abortion in our Constitution. If you want to create a right to abortion, to kill babies in our Constitution, you have to amend the Constitution. You can't just pass laws or executive orders. They'll be immediately challenged and they'll be immediately stricken. That's why the pro-aborts are in an absolute panic, because they don't have the ability to control the court and have legislation out of the court. They don't have an activist judiciary that is rewriting laws. That's exactly how Roe versus Wade got started in the first place. It was an activist court who decided to create this law out of the penumbra and said, well, there's a right to privacy, and somewhere in that right to privacy means that you can abort children. There you go, bam, right? That's what Roe versus, well, that's what it was.
Mm-hmm.
And so those are activist judges. Those are judges, justices, acting like legislators. That's right. And that is what offends me as an attorney. If you're a legislature, if you want to pass laws, all right, you can pass laws. That's your job, is passing laws. But the judiciary should be very, very conservative from the standpoint of a legal, the legal sense of the word, which is you look at something and you say, I can't rewrite a law. All I can do is look at it and say, is it constitutional? Is it valid? Does it follow the laws of our state or of our federal constitution? That's interpretation, and it shouldn't be rewriting a law to say, oh, well, yeah, this statute's kind of bad. I'll interpret it to mean this. That's what activist courts do, and that kind of usurps the power out of the legislature. But the left is very fine with that. They're happy because that's the way we get a lot of laws passed under the black robes of the judiciary, and that corrupts our system.
Yeah. So this is bringing it back to the states, and we're already seeing a lot of different states react differently. I'm from Texas, so Texas is saying we're going to outlaw abortion in our state entirely, essentially. Right now I'm in Ohio, and they say they're going to move forward with their own heartbeat type bill. But then you have states like California, like Washington, who sound like they don't only want to keep it legal, but they want to expand this in the most radical of circumstances. Some are saying even in circumstances where the baby is out of the womb. That being said, for these, it's crazy. I mean, it's hard to sort through sometimes, though, because it's like you hear this and then you dig deeper and then is that what it's saying? I guess go ahead and speak on that before I get into my next question.
Oh yeah, no, I'll absolutely tell you, because the Right to Life League, we were founded in California in 1967. A group of attorneys and medical doctors went to Sacramento to lobby against then Governor Ronald Reagan, begging him, please don't sign the very first, please don't sign the very first therapeutic abortion bill. It was called the Bielenson bill. And once these doctors and lawyers presented it to Reagan and said, look, please don't do this, and then he fully understood what abortion was, he said, well, I've already promised to sign this bill, but I promise you I will never, ever sign another piece of pro-abortion legislation. And he kept his word. So that's where we started. We've been fighting against abortion since 1967. What's going on in our state legislature right now is just abhorrent. There's one bill in particular. It's called AB 2223. It is put forth by Buffy Wicks, so we have called it Buffy's baby slayer bill, because that's what it is. It's an infanticide bill. What it will do is it will legalize all abortion on demand up through delivery and beyond. Here's how it does that. It protects a woman's reproductive choice. And they say, well, we don't want anyone prosecuted for pregnancy loss. And then beyond that, what they say is any perinatal death due to causes that occurred in utero cannot be investigated and is part of basically her reproductive choice. Perinatal death is death that happens after birth. So it's a botched abortion, all right? Also, in California law, the word perinatal, the perinatal period, is already defined in California law as 28 days. So if a baby is born alive following a botched abortion, that baby, and it dies, within the first 28 days, and a doctor can point to a cause that occurred in utero, whatever that means, that's not defined, then that baby's death cannot be investigated. The bill bars coroners from filing certain reports. It can't be used. The toxology can't be used. And there's different inhibitions for the coroners, able to even investigate the death. And any state agency or individual who wants to investigate why this baby died can be sued by the mother or anyone who aided or assisted her in obtaining that pregnancy outcome. In other words, the death of the baby, right? And can sue the person for up to $25,000 plus attorney's fees for finding out why did this baby die. So what that means is if a baby is born alive after a botched abortion, they can just dump it in a bucket and they can say, well, it was a cause that occurred in utero. And no one's going to be able to come and investigate, well, was it really because it died because of something that happened in utero? It's kind of like Nancy Pelosi, you have to pass the bill to find out what's in it. Well, gee, you have to investigate the perinatal death before you know what the cause was, right? But you're not allowed to investigate it. You're not allowed to investigate this death because that violates the woman's right to her reproductive choice. And it also violates the rights of any aider or abettor, anyone who aids and assists the woman in procuring this choice. And it can be anyone. It doesn't have to be an abortionist, doesn't have to be a nurse, a midwife, or anyone with even any kind of medical training. It can be anyone. For example, if your girlfriend says, hey, I just got the abortion pill, because it's chemical abortion is a pill you take and it starves the baby, you take a second pill, and then you have uterine cramps and you expel the dead or dying baby. Sometimes the baby's born alive. But what if you say, well, I don't know what I want to tell my parents, so let me go ask my girlfriend. Girlfriend gets the chemical pill, which you can do now online, telehealth, and Biden has lifted the FDA ban on being able to ship pills just directly to you. So girlfriend gives pregnant woman her abortion pill, and she takes them, and she delivers a baby, but it's born alive, suffering, right? Well, if her intent was to kill the baby, right, and the baby dies, no one is going to be there to find out, well, why did this baby die, right? That you're not allowed to investigate it. And the girl who gave the other one the pill, that she's aiding and assisting, no one can investigate her either. Like, well, wait a minute, I thought there were laws about, you can't share your medicine and things like that. You can't investigate. No, this covers up and blankets any ability to try to help a baby born alive. In California,
did you say this is up to 28 days after birth?
Yes. Up to 28 days after.
So, I mean, all it would take is in the worst of circumstances is, let's say, day 10, the baby's crying all the time. The mom is exasperated. She's like, you know what? I don't really want this baby. All it would take is a doctor willing to kill the baby and say, this happened. This is from cause of happened in utero, and no one would know the wiser because you can't investigate.
You got it. Or just let the baby starve. And think about it this way, the baby's starving, maybe you're not nursing, you're not feeding in a bottle, and a mandated reporter, like maybe child care, maybe newborn care, something like that, maybe a mandated reporter saying this baby's starving to death, right? Well, that mandated reporter may end up being sued. So let's say the woman has a baby and is a Down syndrome baby and doesn't want the Down syndrome baby. Well, Down syndrome is a cause that occurred in utero, right? But you see, that term is not defined. Whatever a cause in utero means, it's not defined in this bill. So a Down syndrome baby is born and you can just neglect it, leave it there until it dies from exposure or starvation. And if it's the first 30 days, well, so long as somebody can point to the cause that occurred in utero, whether it's a botched abortion from chemical abortion or surgical abortion, the baby bled out, who knows, or Down syndrome. I mean, for crying out loud, cause that occurred in utero, conception, hello, that occurs in utero, right? And anything that happens during pregnancy, that occurs in utero. And so what it does is it prevents any investigation. Again, you have to investigate the death to find out what the cause was, but you're not allowed to investigate the death. That's what AB 2223 is going to do. It's absolutely horrific. And the pro-abortion.
this is sure to go through and become
It's
law.
got one more hearing. It's got one more hearing on June 29th in Sacramento in I believe it's the Health Committee. Yes, the Senate Health Committee. That's the last committee that has, each bill has to go through 4 different committees. This is the last one. Basically, it has to get out by June 30th. And once it's passed out of that committee, it's going to go to the full floor for a vote. And they're just going to pass it. They're just going to make it law. And Governor Newsom is just itching to sign it. And that's just one of them. That's one of the bills. So it'll be, if people are saying that, oh, there's no right to abortion. Well, my goodness, California is allowing you to kill your baby up to birth and beyond for up to 28 days. And guess what else California is doing? This is another bill. It's absolutely horrific. SB 1142. That's the abortion vacay bill, abortion tourism. California it's already building the website, and it's passing 1142 to fully fund an ability for anyone in the United States to come to California for free on the taxpayer's dime, to travel there, to get lodging, lost wages, insurance, the free abortion itself, and even childcare. Yes, childcare. So you can bring your kids with you so that you can abort their sibling. You can fly to California. They'll pick you up in probably a Planned Parenthood Uber, take you to the abortion hotel, set you up with your procedure, give you your abortion, whatever it is, and pay your lost wages. You're all totally set for however long you need to be there, and that's all on the taxpayer's dime. And it's
that's what I was going to say. Is this federal funding or state funding that would allow this to happen?
No. It's both, because California already has it has a surplus, a state surplus of close to $100 billion, and that's because of the Biden blue state bailout. Biden sent lots of money to all of his friends in all of the different blue states after the election, and so our state, California's surplus, is $100 billion, close to that. It's a little under that. And so Gavin Newsom has already pledged to spend $120 million to promote his abortion sanctuary. So this 1142, they've got the money. They can fly every woman. Well, actually, they don't refer to them as women. They're pregnant persons. So I'm sure a man who wants to have a free vacation to California can simply identify and claim that he is pregnant. And then he can come out. I mean, there's no, look, in this bill 1142, there's no mechanism for detecting fraud. How could somebody just say, well, I'm pregnant? What if a woman just wants to come to California? She thinks or maybe she's just innocently, she thinks she's pregnant because she's a little late on her period, and so she takes the plane to California. Well, how are the taxpayers going to be reimbursed for that, right? But even worse than that, what about a woman who decides, she's coming from Oklahoma, she's coming from Texas, she gets out to California and she has second thoughts and she says, I can't do it. I really do. I want to keep my baby. Do you think Planned Parenthood is going to say, oh, that's okay, we'll put you on the next plane home? Or do you think they're going to say, oh, honey, we can't pay for your travel and your hotel and your babysitting and your lost wages? That's about, going to be about $10,000 or whatever it is. You have to pay that unless you go through with your abortion.
Wow.
Right? What's going to stop that? Nothing.
Yeah.
That's what SB 1142 will do. And it's going to be using your taxpayer dollars, Texas taxpayer dollars, Ohio taxpayer dollars. It's really what Biden has done to send everything to California. It's an end run around the Hyde Amendment. Because
that's what's so crazy about it, Susan.
Go to California.
That's what's so crazy about it, Susan, is because with this major decision, we've just said it's not a constitutional right to get an abortion, but yet there's no reason that our taxpayer dollars, our federal funds, can't still be used to necessitate abortions, even though we've just said there's no constitutional right. They can still use our federal funds.
Look, they are ignoring the Hyde Amendment, and they're also ignoring the Weldon Amendment, which is similar in California, that says you can't use, money for abortion. They're ignoring it. Look, this is what Maxine Waters was screaming: defy the court, right? To hell with the Supreme Court. We will defy you. They're defying federal law. This is like these groups, the group Ruth's Revenge. Oh, I'm sorry. No, Ruth Sent Us and Jane's Revenge. Yeah, Jane's Revenge, going in front of the Supreme Court justice's home. There's a federal statute that says that that's illegal, but they're not being rounded up and arrested.
It's a perfect segue. That's a perfect segue into what I was going to ask you.
Yeah, go right ahead.
is because, I mean, not only do you have that, but you have, like you said, Maxine Waters saying we'll defy, and then you have our AG, our Attorney General, Merrick Garland, saying we will protect the right, and I mean, and basically also saying the same thing in his own words, that they're going to protect the right no matter what the decision is. So, I mean, have we just reached utter and complete lawlessness? Because how will they be able to uphold this Supreme Court ruling when our Justice Department and all these people are ignoring the law anyway?
Right. What you're seeing is a crisis in the executive branch, because the legislature passes laws, the judicial interprets the law, and the executive enforces the law. And what you're seeing is you're seeing lawlessness. This is really law versus lawlessness, because these Marxist pro-aborts are trying to destroy our Constitution. They are attacking the rule of law. They want to get rid of gun rights. Right? They're appalled that we have a Second Amendment. This is a coordinated attack on our constitutional construct, on our republic. Because if they can do away with the Second Amendment, if they can do away with all of these different laws and these different decisions that protect individual life and individual freedom, right? They can remake America in their own image, right? That's what was promised. That's what.
So is that what they're
Obama
doing?
said.
They're testing the waters. Can we get away with just ignoring the law and do what we want and run the executive branch like a dictatorship? This is the testing the waters phase.
It sounds like we have a rogue executive branch, because the resident in chief, he's obviously not in charge. I mean, they have to hand him a little piece of paper to tell him where to sit down. Like, you sit here and then you say this. I mean, you've seen that on social media. I mean, it's the man is compromised. So we don't really have a president. Some would say we haven't had one for 2 years, but in any event, we have a compromised executive branch. We have a rogue, Department of Justice, Merrick Garland. He's sour grapes because he wasn't appointed to the Supreme Court. So what we're doing is we are seeing these Marxist pro-aborts trying to flex their power to destroy our laws and refuse to enforce them. So yes, we are at the point of law versus lawlessness.
And the other question would be, because they're talking about how to defy the law, they're talking about what they can do, is and we've talked about now precedent. Is there a circumstance in which they can then overturn this? I mean, and what would that look like?
Well, again, if the Congress and the all of the states together can pass an amendment to the Constitution, right? Just like the 13th Amendment, right? That was the Emancipation Proclamation, right? That declared, we're not going to have slavery, right? The 14th Amendment, any of those amendments, it takes a great effort upon the part of the legislature and all of the states participating. We can pass an amendment to the Constitution that would enforce, I mean, whatever it ends up being. I hope it's going to be a pro-life amendment that recognizes the sanctity of human life from the moment of conception through natural death. That's what the Right to Life League has been fighting for since its founding. That's what we believe. I think that's what most Americans believe. And let's get to one other topic that people may not understand what's really going on. The word abortion has been co-opted. It's been taken and massaged and used in a way that benefits the pro-abortion side, the left, if you will, because abortion used to be referring to a medical procedure which was a last-ditch effort to save the life of the mother when her life was imminently threatened. It was a medical procedure and it was extremely rare. Now, abortion on demand without excuse is referred to because they really want abortion as a method of contraception after the fact. That's what they want, and they're militant about this. But what abortion truly is now, what abortion is the intentional killing of an unborn human baby in the womb. That's its sole purpose. If we are really talking about the health of the mother, we should be talking about delivery. We should deliver her prematurely if necessary to save her life. If that means an ectopic pregnancy, we deliver her from the threat of the ectopic pregnancy, and the ectopic pregnancy probably won't survive. If it's a genetic abnormality that is threatening her life, what we do, what medical doctors do, they deliver the woman and give that baby a chance to live. That's that is, to call abortion healthcare is demeaning to the medical establishment, because all it is the killing of life. It is not to save the life of the mother. The vast majority of this, 99%, we're not even talking anything close to saving the life of the mother. But you see, the pro-abortion side has ginned this up and created this and come out with a list of horribles. And then they also suggest, and it's very offensive, that Black, Indigenous, people of color have higher risks of pregnancy, et cetera, et cetera. What they are doing is they are trying to justify the killing of children of color in the name of healthcare. And that's what they use abortion for. So we should absolutely outlaw abortion, because abortion is the targeted killing of children in the womb, particularly children of color, because a much greater percentage of children of color are aborted than are non-children of color, I guess, white children, right? So it is targeted to a certain demographic. We should outlaw abortion. The only thing we should ever be talking about is delivery of the woman with a very humane focus on the premature baby and give it a chance at life. Because as we know, viability has moved. It used to be back, more than 20 weeks. And now it's somewhere around, it's like 21 weeks. It might even dip below that, right? So viability moves. It's not set in stone. And as science and as our medical understanding grows, we may be able to save babies at 15 weeks. Right? So we can't kill a baby at 15 weeks just because it's not viable. That's a sick standard. We should be talking about terms of delivery for the mother and humane delivery of that child to give it a chance at life. And we should outlaw abortion.
I mean, even if a full-term baby was born and you didn't intervene, they wouldn't have a chance at life. And by intervene, I mean
cause that occurred
them.
in utero, right? It's a cause that occurred in utero. Mm-hmm. You can just leave the baby to die there, right? I mean, birth, the process of birth, and doctors still don't understand what exactly triggers the contractions that create birth, right? So that's a cause that it occurs in utero, just the birthing process. And so if a baby is born or damaged during the birthing process, well, that's a cause that occurred in utero. And so I don't have to give it any care. And see, in California, we have a law that it's an infant born alive protection statute in California. It says that a child that is born and survives as a result of a botched abortion has the same rights to care as a child that is, born in a regular fashion, right? So that its intent is to protect the child, right? Well, that's going to be completely overridden, right? Completely.
Yeah. Any final comments?
I just wanted to say thank you very much for the opportunity. I really appreciate it.
Bet.